All right, I think I got some technical glitches sorted out, so you should be able to see the screen a little bit better than the last video. So we're looking at civil liberties and civil rights today. First thing you want to talk about when we talk about civil liberties is that civil liberties are granted through the Due Process Clause of the 14th Amendment. In the Constitution, it talks about writ of habeas corpus, no bill of attainder, no ex post facto law, and the fact that you have the right to trial by jury. These are all key components of creating civil liberties. Within the Bill of Rights, we see a number of rights that are granted through the Due Process Clause. They then are applied to the citizens. These are initially protected from the federal government's infringement on your rights. With the Bill of Rights, the Bill of Rights protected the citizens from the federal government. It's not until the 14th Amendment do we see the Bill of Rights actually being applied to the states. So with the 14th Amendment, we see incorporation, which is where we see the Bill of Rights being applied to state and local government ordinances and laws. Okay, so Bill of Rights being applied via the 14th Amendment is incorporation. And with legislation, we just want to know that that's where we see the laws that are created that really serve as the limits or the boundaries in which people can live and determining what is right and what's wrong. I mean, our courts have established judicial review, which now allows them to interpret whether or not legislation that has been created or an executive order that has been created is constitutionally sound and does not violate the Constitution. All right, so we're going to look at some of the aspects of the Bill of Rights and some of the clauses within certain portions of the Bill of Rights. So Amendment 1 deals with a number of different freedoms, including freedom of religion and the Establishment Clause. The Establishment Clause, simply put, basically says the government cannot create a national religion and you can't use tax dollars to support any one religion over another. So some cases that you want to be familiar with dealing with the Establishment Clause can be dealing with school prayer or usage of Bibles in schools, such as Engel versus Vitale dealing with school prayer. Abington Township deals with Bibles and Bible verses being recited. Lemon versus Kurtzman establishes the Lemon test. It's another school prayer, but it talks about the three areas of whether or not it's a secular purpose and so forth and so on. With the Lemon test, with the Minersville and West Virginia cases, we're dealing with the Pledge of Allegiance and whether or not that is forcing children to say the pledge if that is a violation of the Establishment Clause. Minersville said no. West Virginia will overrule Minersville. And then with Wallace versus Jaffrey, that's dealing with, again, reciting of prayers in schools and so forth in Alabama. Free Exercise Clause is going to talk about the fact that basically religions can be practiced, but there are limitations. If you are going to conduct illegal activities during your religious practices, you are not protected under the First Amendment of free exercise clauses. So Reynolds talks about polygamy. Oregon versus Smith is dealing with drug use. With the other court cases, that's dealing with whether or not the government can create laws that are considered to infringe upon their religious freedoms and so forth. But these are some cases to take a look at. Freedom of speech. There are versions of speech. You can have pure speech, which is you talking. There's symbolic speech, which you could be. It could be an action. It could be a symbol. It could be an armband. Things of that sort. And then you have speech plus, which is this idea of using verbal but also symbolic speech together. Court cases dealing with speech, they range from whether or not you have the ability to speak your mind against war efforts, such as we see in Abrams or Schenck. You could talk about Gitlow, establishing basically that the federal government can now incorporate freedom of speech and the significance of Gitlow. Tinker v. Des Moines dealing with students' rights. Texas v. Johnson dealing with flag burning in Reno versus the ACLU, dealing with other elements of freedom of speech. So know these cases and make sure you look over those cases. With all the court cases, I don't have time to go through all of them, but if you have questions about that, you're more than welcome to stop by my room. We can take a look at that. But again, oyez.org or oyer.org is the best place for you to go for the court cases, to make sure you understand that. So, with freedom of assembly, we are going to look at the Young versus Oregon. That's dealing with a union meeting, whether or not that violated Oregon law. Due process clause of the 5th and 14th Amendment deal with property rights, but also dealing with due process and procedural due process. So basically, when we look at substantive due process, it's talking about whether or not the law is actually fair and does it actually violate constitutional protections. With procedural, it's talking about the actions of the law. So are there policies in place with substantive? With procedural, are there actions that took place that took away from your due process, which means basically, is there a procedure in place and are your rights being protected during the interactions with the authorities or dealing with the courts and so forth? Right to privacy, we see two cases that are important with Roe v. Wade, Griswold v. Connecticut, both dealing with women's privacy, with contraception and abortion. 14th Amendment or 4th Amendment with search and seizure. We're going to look at Matt v. Ohio and a couple other cases. And basically what you need to know from those cases is how do they impact our interpretation of search and seizure, and then how those decisions can actually influence future decisions in dealing with privacy and how evidence is obtained. You need to be familiar with the exclusionary rule with Matt v. Ohio and how that can be applied to future cases such as TLO versus New Jersey and so forth. 5th Amendment, it goes into property rights with eminent domain, but it also goes into self-incrimination. Doesn't infringe upon your due process as far as having a fair process to handle your charges. You need to know Miranda v. Arizona as far as Miranda rights. The 6th Amendment, right to an attorney. Powell v. Alabama and Gideon v. Wainwright are the two cases that you really want to know. You could look at Betts v. Brady if you'd like, but in the end, Gideon v. Wainwright's probably going to be the case that you're going to need to know more than anything else. Cruel and unusual punishment with the 8th Amendment. These are death penalty cases with Furman v. Georgia and Gregg v. Georgia. So take a look at those cases and refamiliarize yourself with that. And then we're looking at civil rights. So civil liberties are established through the Due Process Clause of the 14th Amendment. Civil rights are established with the Equal Protection Clause of the 14th Amendment. And so what we see as civil rights pertains to groups, whereas civil liberties pertain to individuals. So make sure you understand that difference. We did have a FRQ that kind of dealt with that discussion, so I would look over that FRQ. You can find that on the website, or you should have it somewhere in your notebook from last semester or from this semester if you're taking the class this year and you're looking at this video. The 13th Amendment, we need to know the civil rights amendments as it pertains, because the 13th, the 14th, and 15th Amendment are pivotal in what we consider to be the civil rights and civil liberties cases. So Civil Rights Act that and movements that we want to look at as far as the impacts. Once the 13th, 14th, and 15th Amendments are passed, the civil rights movement really takes on an identity through trying to prevent the mistreatment of former slaves and attacking things such as black codes, which were laws that basically kept former slaves out of politics, whether it was literacy tests, poll tax, registration fees to be able to vote. So the Civil Rights Act of 1876 basically outlawed racial segregation in public places. Jim Crow laws, though, on the other hand, created segregation in schools, public transportation, and hotels. The reason why they could do this is because of the agreements with the election of Rutherford B. Hayes and the end of Reconstruction. Once the military left the South, and Reconstruction ended, the Civil Rights Act of 1876 lost its teeth, and the South reverted back to their old practices with black codes and Jim Crow laws. And then we see the court case of Plessy v. Ferguson, which legitimized Jim Crow and made it legal constitutionally, with the precedent being established with separate but equal. They actually used the 14th Amendment Equal Protection Clause to support segregation in this decision. So, Executive Order 8802, Franklin Roosevelt, during his presidency, is going to ban racial discrimination in the federal government. We had a segregated government up until that point, where literally you would have black employees and white employees working in different buildings. Harry Truman is going to desegregate the military after World War II, which is extremely significant as far as putting African Americans in a position where they're getting the respect that they earned and deserve throughout the history of the U.S., where we desegregate the military. Because we were just coming off of World War II, it served as a pivotal representation for the entire country to see that segregation was something that needed to be addressed and ended. And finally, we begin to see the courts. So we have the executive orders being passed to try and tackle discrimination and racial segregation, and the courts get on board in being able to come in and attack the issue of segregation with Brown v. Board of Education, which overturned Plessy v. Ferguson. It's still going to take time to get segregation addressed wholeheartedly and completely. The 1960s, we see more actions taken by the government with the Civil Rights Act of 64, where you begin to use the Commerce Clause to enforce desegregating public places and places of employment. You also have the Voting Rights of 65, which now outlaws literacy tests. It's not until the 24th Amendment, where we get rid of the poll tax, that we see elections really being addressed. With women's, the 19th Amendment is going to give women the right to vote. The Equal Pay Act of 63 is going to make it illegal to pay someone a different amount based off their gender, race, religion, or national origin. It's still an issue that exists with a pay gap between males and females, but nonetheless, there have been pieces of legislation that were put in place during the 60s and the 70s to attempt to tackle that. People with disabilities, we need to make sure that we understand the Rehabilitation Act of 73 prohibited discrimination against people with disabilities in federal programs, but it's the ADA that actually forbids employers and all other institutions from discriminating against people with disabilities. Again, remember, the ADA is an unfunded mandate. Therefore, the burden of expense is on the states, where the federal government will create the standards, but the states have to adhere to those standards. And then affirmative action, we looked at that as far as really the biggest place we see affirmative action is going to be in the college admission, and the court cases that we looked at with University of California versus Bakke, dealing with whether or not you could use quota systems, and we see that the courts ruled that you can have affirmative action programs. Those are fine, but you cannot use a quota system in that. But race can play a part in determining how you're going to accept students and using it for admissions and criteria for admissions. So that's the PowerPoint portion of our review, but I want to take a look at our outline while we have a little bit of time. We are about a minute left, but still. So here are your court cases. Again, this is all on the class website. You'll be able to find it. It's an easy link, but there are a few more court cases on here. It is broken down on the topic, so you are familiar with the topic and the ins and outs. You're more likely going to see a court case used on an FRQ, so make sure you review these court cases. And then you have your civil liberties outline.
Susan McDonald, if you're in the building, we need you to move your car immediately. Susan McDonald, we need you to move your car immediately. Thank you.
Okay, and make sure you take a look at this outline. It kind of hits on the things that I just talked about and throws in a couple more questions. So just keep in mind that you need to make sure you review this stuff. And if you ever have questions, just reach out to me. You can email me and we'll set up a time, or just stop by in the morning. And we should be able to get something sorted out so I can help you answer questions that you might have. Okay? All right, well, good luck reviewing this unit, and I will be back with Unit 3 sometime in the next few days.